Yes, Mr. Roux.
Thank you, my lady, and learned assessors.
Yes,
My
Mr.
lady,
Roux.
we made available copies. Thank you, my lady, and learned assessors. My lady, we made available copies after its argument, and this morning we handed to your registrar the case law referred to in the heads of argument.
Yes.
We have not as yet received the heads of argument on behalf of the state, but it's no impediment for us arguing this matter.
Okay, thank you very much. May I just find out from the state when your heads
We
might
have it
be ready?
available.
Pardon?
We have it available. We make it.
Against that, it is so necessary to carefully look at the facts as found by the court to try and understand in the context of this tragic event what should be suitable as a punishment and what not. And I can place unconditionally on record, it was asked to Mrs. Vergeer, but I place on record that there's an absolute acceptance by the accused of the judgment. It is on that basis that we argue mitigation. But what is important if one has regard to the judgment? And further, at page 3347, where the court repeated this by saying, from the above, it cannot be said that the accused did not entertain a genuine belief that there was an intruder in the toilet who posed a threat to him. And then at page 3334, coming to the culpable homicide, very correctly, I believe the court found that I'm of the view that the accused acted too hastily and used excessive force. And at page 3328, the court found clearly he did not, and I'm just reading one part that's important, he did not subjectively foresee that he would kill the person behind the door, and then importantly, let alone the deceased, as he thought she was in the bedroom at the time. Now, my lady, honourable members of this court, I have no doubt that the state would present you with cases to tell you about deterrence, to tell you about retribution, The negligent conduct. Yes, of course, there's a high degree of negligence when you fire shots into a door when there's someone behind. No one can dispute that, but we cannot isolate it. Is it just someone walking to the door, thinking there's an intruder and recklessly firing shots into the door? Or is it a compromised person reacting excessively? Yes, it was, my lady. It's not what we are saying. It's the evidence of a highly regarded independent psychologist, Professor Scholes. It was the evidence in context. Any deviousness? Was there any conscious unlawfulness? There was not. And what happened, my lady, and I need to share this. On the bus here from the train station 2 or 3 days ago, I was approached by, I think, an attorney had a briefcase. I don't want to say anything more because I don't know the man. And he said to me, Mr. Roo, have you ever read the book Ubuntu and the Law? And unfortunately, I did not. And I said, well, I did not. He said, maybe you must go and read the book. And I went back from court and we bought the book and I read through it. And it changed the perspective. And I was thinking to myself about the principles. And we referred to case law, sanctioning the principle. But I was trying to make out for myself, what is Ubuntu? What does it mean, humanity? What does it mean, humanity within society? And all the descriptions and absolute correct definitions by Justice Yvonne Magoro on what it is and why that should form part of our legal system. And I was thinking back to try and find a situation that would explain it to me. And I was thinking of a person stealing a goat from another person. And you can do two things. You can take that person and put him in jail now for 2, 3, 5 years, 1 year, whatever. That's not how I understand Ubuntu. I'm not saying there are not cases where whatever you do, you cannot escape a custodial sentence. I'm simply dealing with the principle. And what it says to me, how Ubuntu worked and must still work, is in this way. Get him to give the goat back, and if he cannot, get him to do something to that society, to compensate, to work back, carry water, do whatever. Do something good in society, coupled with your apology, that everyone can benefit. The victim, the family, and the restorative justice principle that could not be separated from rehabilitation, where that person stealing the goat is back in that community, he pays the price in a very correct and restorative way. And then when one looks at the case law, where Justice Bertelsmann dealt with that, and we will refer to this case, and 2 judges in the Western Cape High Court explained this principle, one gets a far better understanding of the real meaning of restorative justice, and a far better understanding of the judgments that I will refer to, saying previously it was as if it was standard. You commit a crime and you must go to jail. Maybe there are cases that we must just sit back and look again and see, is that really what the law is all about? And of course, there's always one danger, and that's the wrong concept of society. The society is very different from the interests of society, and the case law makes this clear. In society, there will always a part of society that would want the death penalty for the accused, irrelevant of what the court's finding is. In society, he will always be crucified by some people as a cold-blooded murderer, and I will deal with that. And they would want the maximum sentence. But that's not the test. The test is what is in the interest of society. And that's why the court is there, because the court is the ultimate custodian on behalf of the interest of society to say, taking into account all the facts, what is really in the interest of society? Do we have simply to say, because the man acted negligently and raised the bar on the negligence, for that reason he must be removed? That's what society wants. It's not what society wants. Is that in the interest of society, if regard is had to the peculiar circumstances also of his frame in mind? And that's what should be entertained and carefully considered. We say, my lady, that what happened in this matter was this. There was an accused and a victim. And very shortly after this, the accused became a victim. And I will explain why I'm saying that. And it is for this reason. He was charged or taken to the bail court on account of premeditated murder. It's not in dispute that the investigating officer gave false evidence. It was accepted in the trial by Captain Mangena that it was not possible for him to have said certain things. That played a crucial role in bringing out the finding of premeditated murder for purposes of bail. Now, let's just stop there and let's go back to the court's judgment. What is reality? Reality is this. We have a man that negligently, in an anxious and vulnerable frame of mind, caused the death of a person that he loves. Can we dispute the relationship? Can we dispute how he felt about it? It's easy. We just have to look at the expert evidence. There is not a single witness refuting what Professor Scholes was saying about how the accused felt, not only about the deceased, but how he experienced the death, the severe emotions. It was confirmed by, he was objective, independent. It was confirmed by Ms. van Schalkwyk, who had nothing to do with the accused team, who was in fact appointed by the police to say, insofar as you're saying that he was just standing there and not feeling, that's not true. These are the emotions, extreme emotions. His feelings for Ms. Steenkamp, his feelings for the pain caused to the parents. That was the theme of her evidence. That was confirmed in the evidence of Dr. Foster, Professor Foster. That was confirmed in the evidence of Dr. Hatzenberg, saying some sessions, there was no talking. There was no therapy in a way that we know it. It was weeping and I was holding him. That's all I could do. Those extreme emotions suffered by a person of the accused are not in dispute. There are expert witnesses confirming it. However, what happened? Now you must take that person, go fast forward with respect, my lady. You must fast forward to the ultimate result, that he never, ever even considered that it was Ms. Steenkamp behind that toilet door. Never, ever, that he genuinely believed that he was in danger, she was in danger, and that she was in the bedroom. What has now happened to this man? And we will deal with that, what has happened to him. A very different picture And it is this. He became a premeditated murderer for the wrong reasons in a bail application. Some of the members of the media, ably assisted by the social media, started with the wildest speculations. We will deal with that. How he crushed her head with a cricket bat. How he murdered her because he was under the influence of alcohol and steroids, roid rage, and so on, and so on. How he was taking acting lessons when he was genuinely highly emotional to come and pretend that he had feelings. That is what he was subjected to. I was thinking to myself, ever in the history of our law, and I don't believe in any country, have I seen an unfair attack. And I can understand, I can fully understand that the NPA opposed any broadcasting of the Divani matter. Because I will show to you, and we have annexed some of the media reports, how the accused was told to look at the photo of the deceased there. He loved her. He felt horrible about her death. Horrible. He showed that. He made a mistake. That photo was published worldwide under the banner Cold-Blooded Murderer. We'll show that to you. That is what happened. Would there be any apology after the court's judgment? Would there be any retraction? Oh no. Either silence or trying to find fault. Either silence, because we don't do that. That's not how we treat an accused. By some members of society, I say some members. My lady, that is what's happened to this man. He's lost everything. He was an icon in the eyes of South Africans on what he has done, what he has achieved. He was denigrated to the extent that all that was left was a rage killer, a cold-blooded killer, a liar, and everything that's horrible. He lost all his sponsors. He lost all his money. He has nothing, my lady. He hasn't even got money to pay for legal expenses. He has nothing left. We explained that the last asset was his car. He sold that, not to try and get a better sentence. It was try to do everything possible to make good. His attempts to apologize, where he was said that it's not genuine, that he's abusing a public platform. Why could he not do it in private? That's what's happened to this accused. He was attacked from the beginning to end, and we know now on incorrect facts without ever any apology. Now, with that in mind, my lady, when we look at the case law, and I'm not going to repeat everything because it is there, but at page 3, I refer to the Van der Westhuizen case, and the reason I do it is to go back to say even in 1974, it's paragraph 9, my lady. In 1974, where the judge stated inter alia that justice must be done, but it must be done with compassion and humanity, not by rule of thumb. That humanity principle is exactly what we deal with in Ubuntu. It's Ubuntu and the law, African ideals, and post-apartheid jurisprudence. It is exactly the theme of the book. In the next case, it is the S versus GL, where the court said, with reference to correctional supervision, and he says, I remain aware, that's page 4, that a non-custodial sentence of correctional supervision in terms of section 2761H is an appreciable, even a severe sentence. I'm mindful, furthermore, of the shift in emphasis in our penal system from retribution to rehabilitation, referred to by Langajay as he then was, and where it says, in assessing an appropriate sentence, it is necessary to have regard not only to the main purpose of punishment, namely deterrence, prevention, reformation and retribution, but also to the individual concerned, the circumstances of the crime committed and society's interests, whilst at the same time blending such sentence with a measure of mercy. And we will develop this to bring in Ubuntu. In Shariva, I'm not going to read the whole quote in paragraph 11, page 4, bottom of the page. The court explained, Ndao J. Second, there have been concerted efforts to shift from the more traditional methods dealing with crime and the offender towards a more restorative form of justice that takes into account the interests of both society and the victim, i.e. community service. Another instructive case is paragraph 12, page 5 in Sanei. And the court there referred with approval to a number of cases, and I will just read one paragraph. It's the second last paragraph on page 5, paragraph 12, where it says, many of those concerned in administration of criminal justice had acquired a particular mindset as a result of years of habituation to the idea that imprisonment is the punishment of choice for serious crime, and then so important, and it required a basic mental shift to regard imprisonment as a sentence of last resort. My understanding of this is your first inclination when someone has done something wrong that's serious, your first inclination is he must go to jail. But all that the court is saying is be careful that you do not become trapped in that mindset. Just sit back. Society has moved on, and ask yourself, is there another suitable way that would be in the interest of all parties? Is there really a way for restorative justice? Is there a principle of Ubuntu that can be applied? And that's all the judgment is saying very correctly. It carries on with reference to the correctional supervision at the bottom of the page. It says, as regards correctional supervision, in terms of section 2761H, a useful guideline is afforded by the decision in S versus R. And it says, namely, that a clear distinction should be drawn between those offenders who ought to be removed from society by means of imprisonment and those, although deserving of punishment, and even severe punishment, should not be so removed. In the Matiwane case, my lady and learned assessors, page 6, paragraph 13, Judges Samele and Judge President Shlope specifically dealt with the Ubuntu principle. They equated the principle to compassion and humanity. But we have shown to you in the book Ubuntu and the Law that it's more than that. Ubuntu is not only compassion and humanity. It is that strive to protect society and see if this whole incident or a crime can be absorbed into a restorative punishment, into a punishment that will serve the interests of society, the people really bereaved, and the accused. And to try and find that balance. And that's where the court in page 8 in paragraph H, Roman 1 said, it is a balanced and humane state of thought. It is a balanced and humane state of thought. My lady, when we specifically deal with culpable homicide, we say, it was correctly said, that you cannot disregard the actual consequences of the negligence. We're not trying to do it. We're not watering it down. It is just absolutely tragic. But if we really look at comparable cases, and we'll never find the same case, although I will show you one that I thought was a mirror image. We can look at a case, and I've given it to you, and I'm not going to deal extensively with that because it's before you and the copies of the cases there. It's a state which is Warren Foster, Doherty, and Ndunge. Now, in the Doherty case, my lady, there was a conviction of culpable homicide where a volley of shots was fired, and the court ultimately did not send the person to jail by applying all the principles. There's the R case that was referred to. In the Foster case, by considered by Judge Borchardt, I need to read at page 13, paragraph 19, this one paragraph. Ms. Persat for the state asked for a sentence of imprisonment, and she cited a long line of cases dealing with sentences which have been imposed recently for the crime of culpable homicide. None, of course, is directly in point. Many deal with assaults that went too far and led to the death of a victim. Others dealt with death caused in motor car collisions, where people throttle others to the point where the other person dies, or where they overtake on blind rises and collide with oncoming traffic. I quite agree that jail sentences should usually be the order of the day, but in this case, and then it goes on. Now, what happened? In the Foster case, there was a Zozo house in the yard. The accused in the main house perceived that there was an attack on the grandson of his helper in the house. There was a good relationship. He fired the shot. That shot went through the window and hit the little boy in the head. The court found at the bottom of page 14, Mr. Foster was beside himself with grief, pain, and remorse, to the extent that the police brought in a trauma counselor to the cells to try to help him. It is now almost 2 years later, and Mr. Foster is still clearly in a state of post-traumatic shock. I've never seen before an accused person as devastated and remorseful as he is. He has had therapy initially apparently from someone connected to his church, but since May 2010 from a clinical psychologist. The mother, for obvious reasons, she rejected offers. She felt her son died like an animal. The court ultimately considered sentence and found that it was better or more suitable not to impose custodial sentence, but to impose a community-based sentence. In Madunge, my lady and learned assessors, at page 17, I want to show the state's attitude in a different case. It is at paragraph 20.1. In the Madunge case, Madunge and the deceased were sleeping at their home when approximately 12:30 in the morning of 13 April 2011, Madunge was awoken by a strange noise like a window opening. Madunge thought that a burglar was trying to get into the house, and fearful for his life, he grabbed his gun, which he was kept in his bedside pedestal drawer, and made his way to the entrance door of the room. He could hear the noise coming from the bathroom. He slowly made his way to the bathroom door to investigate the noise, with the thought that the burglar was hiding in the bathroom. As Mr. Madunge reached the bathroom door suddenly slid open, and Madunge, afraid for his life, panicked, and being startled by the door suddenly opening, he fired a shot at the person who opened the door. After he had discharged the shot, he realized that it was his wife that he had shot in the thought that it was a burglar. He rushed her to hospital and so on and so on. The state there, the NPA, entered into a plea and sentence agreement where they agreed to the following sentence, and that sentence, in terms of Section 105 of the Criminal Procedure Act, was considered to be just by the court, where it was agreed that a just sentence in all the circumstances shall be that the accused is sentenced to 8 years imprisonment, which is wholly suspended for 5 years on certain conditions. We also referred to a newspaper report again where there was a wrong shooting, where one person was killed and the other seriously injured, where he was mistaken. And again, there was not a custodial sentence. Now, on page 20, we're not going to deal with it. It is there for the court. Are all the sentence options in terms of the Criminal Procedure Act. We have no doubt that the court has many times dealt with those options, and it's before court and the learned assessors. We then deal, my lady and learned assessors, with the accused's personal circumstances. He's 27 years old. Now, 27 is not young, but it's not old. You're relatively young, and you don't have all the wisdom that you get later in the years. And it's just a factor to be taken into account. We have dealt with his disability. I'm not going to repeat that. We have, for the benefit of the court, summarized some extracts from the evidence, just to show that what we say is there. We have dealt with the difficulties that he had, and the pain and the suffering and the consequences of the amputations, and the present difficulties that he experiences. Is a first offender. We deal with his situation. What has happened to this man? He was on the rise, my lady, and that was very clear in Mr. Van Zyle's evidence. He was on the rise. He was like an icon. He was going to make lots of money. We could see, as a young man, to already at that time have 1, 2, 3, 4 immovable properties, albeit some of them stands. That's not what you get when you're 26, 27. So he was on the rise, and Mr. Van Zyl explained that it would have become 5 times more. He's lost it. He's lost his immovable property. He's lost his movable property. He has not earned a penny since. He has no sponsors. It's a person that's down and out. He's broken. He's not only broke, but he's broken. There is nothing left of this man. But we will show it's far worse than that. What's happened to this accused? It's far worse. My lady, page 25, when we deal with the mitigating and the aggravating factors. I in particular would want to read paragraph 37. Because, my lady, it is so easy to say, when you kill someone, you must take the consequences. You must live with the consequences. Of course, my lady. You must live with the consequences that's fairly attributed to you. Of course. Of course. But that's not what has happened in this case. It went far beyond consequences flowing from crime. The denigration, the humiliation, the ridicule, the blame, the false allegations, ongoing, worldwide, persistence, continuing. That's what he was subjected to. He stands there, so that in a box, giving evidence and crying, knowing the whole world is listening to his emotions. He was absolutely exposed. And it's fine when it's exposed, when it forms part of the consequences of your actions. You must take it on the chin. But that is not what happened in this case, my lady. It went far beyond that, but we will deal with that. If I may read paragraph 37, what we state in the heads of argument, where we say, the fundamental principles to punishment have shown that direct imprisonment as a sentence option should be a sentence of last resort, and that an enlightened and just criminal policy requires a broad scope of sentencing options from which the most appropriate option or combination of options can be selected to fit the unique circumstances of the case before a court. We say that the court is the representative or custodian of the interest of society. That is the public interest. But that society is an informed society and not a society consisting of vengeance, overreaction, and emotive incitement premised on uninformed allegations and speculation. The last mentioned do not represent the public interest, and no sentence other than the most extreme or harsh will unfortunately ever satisfy them. We say that it's significant, and there's really nothing that I can say about that, but with great admiration, absolute admiration, that the parents of the deceased who have suffered the most remained neutral in the sentence to be imposed. That is in Ms. Vergeer's report, and my lady, if there's any doubt about the correctness, you will see the press statement released on their behalf. There is no vengeance in that. They leave that in the hands of the court, which is proper, but I can only admire them for that. My lady, page 27, we say, but let's look at further consequences. When I think of Mr. Vleisversace, a well-known rugby player, he's short. He killed his daughter. She was driving out with the car. He thought it was a thief. He shot her. She's dead. I cannot begin to try and understand the pain. I cannot begin. The state had great appreciation. They didn't charge him. They did not charge him. And I understand it. And I understand why the accused is there. But it does not mean that Ms. Steenkamp was someone that he thought was a burglar and shot her. That's not what this case is all about. It was the person that was important to him. It was the person he loved. We had ample evidence of the relationship. We have Professor Scholz's report confirming the true emotions, confirming the true pain. And one thing that as a human you need to do is to have that grief. But what's happened to the accused in this matter? Of course, when you cause the death by your negligence of a loved one, there's grief for the loss. But there's something far more than that, far worse. It is that permanent, excruciating pain, is that it's you that caused the death of a loved one. It is you. That will never go away. Whatever punishment, lifelong, 15 years, 10 years, correctional supervision, that can never be equated to that pain, as it can never be equated to the pain experienced by the parents. But it's an emotional pain that's deep and it's permanent. But for the fact that the one is aggravated by blame. And it's there, my lady. It will not go away. Instead of them having at least that one process of grief, what's happened to the accused? He tells his story immediately. He was vindicated in his version. That one that he told immediately. That one that he told at the bail application, where no one could understand, lawyers. How could a man disclose so irresponsibly at the bail application already his version? That is silly. That's what the accused wanted. He said, I want to tell my story. I want to explain what happened, right from the beginning, not later come out of the story. That's what really happened in this case. And then, what happened to him? He became, for 18 months, a premeditated murder. We must, with respect, understanding, and that's in paragraph 45, my lady, when it's so easy to see the accused as a strong man running around the track and winning gold medals, be triumphant, that's fine. That's fine. But we know what Professor Scholes was telling us. We know what Dr. Hatzenberg and Professor Foster were telling us of the other Oscar, the other side of the accused, when he's out of that limelight, when he's on his own. And that is where he found himself for 18 months, on his own, and hammered, denigrated. That's what happened. No punishment that the court might impose can be worse than the last 18 months. My lady, all of the submissions that I've made would be in more detail at the pages 26, 27, 28, 29, and 30. But I think, with respect, that I should maybe just refer to this in paragraph 55, page 30, where we say we refer hereafter to instances of extreme harm caused to the accused. Now, when that extreme harm is there, and it's fair reporting, and it's fair in the social media, and it's real, it follows. That's one of the consequences of the offence committed to you. But let us look at what's happened to him. The denigration.
Before, just one minute. There's something that concerns me about about your paragraphs on the media. I'll tell you why I'm concerned. With evidence before court, the court can take account of it, simply because it was evidence, it was tested, so you know what allegations are true, you can weigh that. You know what allegations are not true. With reference to the media here, how is this court to know this is true, this is not true?
My lord, if I may answer that's an absolutely fair question. What it's about is not the truth. Mm-hmm. What it's about is factually. That is a report in the media. We attach that. Factually, that's a publication. And factually, that publication is false. And all we say, if you're faced with a publication today, what does it do to the accused? That's all we say. It is not that there is no publication.
No. I understand that. I mean, I saw that. It's just that I did not read that.
My lady, it is a factor when an accused is subjected to unfair publications that's not consistent with your finding, to say, but it must have done something to him. It must have been a punishment to him in itself. To read that you a cold-blooded murderer, that you suffer from roid rage, that you crushed the skull with a bat, it's a factor. It's not over, but it's a factor.
Yes.
To say, this is what he's gone through. Only to that extent, my lady. I think your question is correct, and if I did not...
If you put it that way, only to that extent.
Only to that extent, my
yes,
lady. But
because you must remember, it is very important for the court to make sure that he or she is not influenced by anything that was not part of the evidence,
no.
Whether before the conviction or after the conviction.
I agree, my lady. But this is where we say, as part of mitigation, where we put all possible factors. And we say that is a factor, but only to that extent. Only to that extent.
No, I'm happy. Thank you.
My lady, and that is why we annexed page 31 and page 32. We have dealt with it, and 33. We're not saying it's not there, and 34 and 35. I've dealt with that. We're not saying it's not there. We're not saying it's the beginning and the end, but we say there are the reports. That is what it's done, and you just have to read them. It's not about the reporting itself, it's what it did to the accused.
Yes, no, I understand.
Thank you, my lady, page 36, paragraph 71. I don't want to go into too much detail here. But I often wondered, particularly after the judgment, if I'm a parent and I must listen to screams, witnesses telling it's my daughter screaming. Must be terrible. But it is also terrible to the accused sitting there and thinking, I'm getting blamed, where I negligently shot her, not knowing it's her, where I now must hear about her screaming, which we know was not her screaming. You cannot escape one thing there, my lady, that pain and suffering also experienced by the accused to think, what is this? And it's there. The consequence of that is there, my lady.
You're talking about the evidence in this court.
Yes, my lady.
Yes.
And we know it was not reliable. I'm not saying mala fide, but not reliable. All I'm saying is you sit there also as an accused person when you hear something that is not correct, and it causes anguish, not only to the parents, but also an accused. It's part of that process where it's a moral punishment over and over again. That's what I'm saying there, my lady. My lady, page 37, top paragraph 75. I point out to the court, I say, let us look what has happened in this case. He lost the person he loved. He lost his self-image, self-respect and dignity, most of his friends, his career and his source of income, all of his immovable properties, all his money and his reputation. That's fact. He's lost everything. Now, if we focus on the accused, and we go back in the history, because it's also important for the court to look at the person of the accused. And it's for this reason, when someone stands trial on a murder or a robbery, and you look at this accused, and you look at the background of the accused, and you see, but robbery before, murder before, this, that, you have an understanding who you deal with. It is in that sense that we say, if you look back at the person of the accused, and to see, is this a person that you must remove from society based on his personality, based on his character, then we say no. Let's see, when he had fame, how he reacted to and how he related to people around him. It is true that as sportsman and part of sponsorships, you do charity work. It's a request. It's not an obligation, but it's something that you will do. What is important is Mr. Van Zyl's evidence, how he did it. How he did it. It was just that extra step. But more importantly, that is the person of the accused. Outside the sponsor request or responsibility, he was busy with his own foundation, free of charge, for the upliftment of people with disability, to help them. He was doing charity work. We've seen the photos. We've seen that how he wanted to do it and the way in which he executed, he performed that. It was not good enough to put it to him, but it's not your money. When you ask, instead of paying it to me, please give it to someone else. Instead of giving me money for shoes, give the shoes to her. It is his money. He just didn't formally put it in his pocket where he could get it. He was doing that many, many times. Mr. Van Zyl explained there are many, many instances. And he did not receive a doctorate because he could run fast around the track. He did not receive a doctorate because he could encourage people with disability that they can do better than they think they can do. It's part of it. But he was also awarded that the whole last part in the document, because of the way he conducted himself, the way he conducted his charities, what he was doing for certain members of the community. That is the accused. So it's not a person where you feel that when the society is exposed to them, that one must be careful and think that it's not in the interest of society to expose him to society. The contrary is true. And it's in that respect that his work and the doctorate's important. My lady, the money, it's not to the parents. It's pages 39 and 40. It's not about the money. It is just showing to the court the accused. It is just showing to the court where he's so many times accused of not taking responsibility. It's showing that when there was an approach, that he immediately reacted to it, not to be published to anyone. Not to be published. It came out at the end because as legal representatives, we held the view that it was important to show to the court the person. Everything was important to put before the court. And to say, there it is. It was an immediate response by him, not to be showcased to the world. It was private. The same with the other money. When an approach was made by the legal representatives on behalf of the parents, without their knowledge, acting responsibly and say, there may be legal actions, can't we resolve that? There was an immediate response, an immediate willingness to reach an agreement, and then an absolute respect when the parents said, we don't want to institute action, we don't want your money. A respect for that. But he went one step further and said, in case you feel differently, not, oh yes, now I can keep the money. I don't have money, but at least I have now 375,000. No. Not I owe you money for legal fees, rather there's some money for your legal fees. No. That's not what life's all about. It is rather this. I offer to pay it in any event into a trust account, should they consider. And when they came back and said, no, they've made up their minds, my lady, you would see an offer here to say, if they want, and it's in the court's discretion, the court has wide discretions in sentence, that money does not want. And we understand that they want to return the 6,000 per month. I don't want it. If you want, give it to a charity. Give it to someone or some entity that you feel would be in the interest of society. I don't want that. I want to do more. It's my last money that I have. I have no more. I offer that, and that offer is still there. We've made that offer here and say, if Mr. De Bruyn, acting on behalf of the family, would consider that, that's fine. It is there. It's unconditional. It's not prescriptive. It is not to impress the court. That is there. That's what he wants to do. He wants to do more. He wants to show that there's compassion, there's emotion, there's hurt. He wants to make good. You can never make good. He wants to make good as far as possible. To what extent possible. That's what he wants to do, my lady. My lady, I've dealt with page 40, 41, with the mourning. I've quoted Dr. Hartzenberg. And it is really before the court. If I may just refer to page 43, where we say, at the bottom, actually page 42, paragraph 87, we say it's respectfully submitted that there are a great number of mitigating factors, clearly indicating that the punishment of the accused already commenced immediately after the incident, and that the emotional trauma and devastation on the accused as a result of the incident is far more severe than any criminal punishment could be. We make the point by submitting that generally offenders would be punished and thereafter continue with their lives. I've acted many times. He does something wrong, he gets punished, and it's over. There is no over here, my lady. We say in this matter the effect on the accused is permanent and the damage done is there forever. It's there. My lady, and Leonard assesses page 43, we deal with the emotional effect. That's all before the court. I'm not going to repeat it. The only reason we put it in was for the benefit of the court and Leonard assessors to say, instead of, should you want to look at it, extracting it from the judgment, we have extracted it. How he reacted, the court very correctly found on this, and it's not necessary to go into detail here. That's pages 42, 43, 45, 46, 47, showing his emotions, showing his remorse. Page 49, 50. It's not what we're saying. It is so easy sometimes, and we all know it, when you act for an accused and is convicted, and to stand up to say sorry he is. What we see here is not to stand up and say how sorry he is. We take the court back to the evidence, what other people saw, how he reacted. We leave out his own version to say, how did the accused react? What did Dr. Stipp see? What did Professor Scholes experience? What did Professor Foster experience? It's already there. It's very different from just verbalizing it and say, now that we're convicted, we're very sorry. It's very different in this case. It carries on page 50, 51, 52, 53, my lady, 54. Again, with his anxiousness and the role that it played, we really satisfied that the court put it in the correct context. It is again there, all the page references to show what it has done to him, what role it played. We, at page 60, what is instructive, my lady, is paragraph 114.4, where we say, Dr. Foster also testified, individuals who are anxious, I quote, try to manage their environment to bring order to their lives in order so that they control it. It's important. They are so dependent on an environment that they can control in order to overcome the difficulties of vulnerability and anxiety. And we ask the court just to keep that in mind as a factor. When you take this person and you put him in a jail, we know one thing, that if you look at Dr. Foster, when you look at Professor Scholes' evidence, that is not conducive to at all assisting him in his anxiety and his vulnerability and the effects thereof. We refer you to page 115, where we know what he's suffering from post-traumatic stress disorder, depressive disorder, and clinically significant press. And what is important, my lady, for purpose of sentence, at the bottom of page 60, paragraph 116, we say, Professor Scholes further reported that the accused did not attempt to manipulate, does not suffer from clinically significant aggression, anger or hostility, and he did not attempt to malinger. And very important, that he did not have personality characteristics that would make him dangerous. And it's important because sometimes, unfortunately, with Ubuntu, with restorative, when you have that dangerous characteristic, we have a difficulty in law. What do you do with the person? It's not there. (118), paragraph 108, page 61, we refer again to Professor Scholes when he's dealing with the degree of anxiety and depression present in the accused. He said it was significant that he should continue to receive clinical care by a psychiatrist and a clinical psychologist. He also submitted that should the accused not receive proper clinical care, then his condition is likely to worsen and would increase the risk of suicide. My lady, page 62, we dealt with the vulnerability. It's there. It's again just to the convenience of the court to say these are the extracts relevant to it for you to consider in its proper context. Likewise, my lady, learned assessors, page 67, we deal with disability, but what I would ask this court with great respect, my lady, what was really significant was what's contained in paragraph 140 at page 67. We don't realize that when we see disability. We don't realize the real impact and effect of disability. And he was explaining the difficulties encountered. I'm not going to read it, my lady. It's all there. That sometimes we miss it. It's pages and pages of his research. 68, page 69, and page 70. We refer to Dr. Versveld saying that there's constant medical attention, that he's not just walking around on his prosthetics and it's fine. There's pain, there's treatment, there's adjustments that he must go through. That's also page 71, 72, and 73. That brings me page 142, paragraph 142, page 72, my lady, to the evidence of Mr. Modise yesterday. And what I was understanding from it was that he twice conceded when I asked him that, in inverted commas, the normal jail outside the hospital section is not suitable to the accused. They don't have showers and so on and so on. I accept what he says. And he says, but however, we have a hospital section where he can go to. My lady, I try to understand what is there? How many inmates are there? What is wrong with them? What would his exposure be? I don't know. I still don't know. So it's fine to say, well, we understand that our conditions in the jail, however we want them to be hugely improved and we want it to be wonderful, it's commendable that we're not there. But put him in a hospital section. No, my lady, it's putting him with people suffering from ailments, diseases. For how long? What must he do there? Must he stay in hospital? Must he not come out? Must he not, like another inmate would do, get involved in outside work? He's now protected in a hospital. It can never be a suitable punishment. It is by locking a person up in a hospital. And is there really a dominating factor calling for that? Yes, if it was an accused that deliberately killed and a normal jail cannot accommodate him, and we have to remove him from society, yes. But that's not the case. Even if we lift the bar on negligence, it does not make a difference, because at the same time that you lift the bar of negligence, you have to balance it again with what he suffered from that anxiety and the vulnerability and the slow burn effect of his disability. It's again a balancing act. It's not that person callously walking and committing a crime and then find himself to be negligent because he failed to foresee. That's not what it was. It's not that person racing down a street, consciously committing a crime, and then failed to foresee and reconcile himself with it, and therefore end up with, on principles, culpable homicide. It's not that case. So, however high you want to raise the bar, you cannot raise the bar in isolation. As you raise it, you have to say, but there must be compassion and understanding for your excessive force. It's excessive. It's wrong. But it cannot be isolated. It's one package that must be considered in context. My lady, when he was asked about correctional supervision, in whatever form you may consider this, because it can be combined with many sentences and many conditions, he said, and that was important, that the system has improved. We all know right in the beginning that there were difficulties in monitoring. It has improved. The court has a discretion, as we've seen in the Foster case. That's a very good example, to say, well, I hear what you say, but that's what I want the person to do. I'm not going to allow you to be in comfort. I'm not allowing you to do what you want to do. That is what you do. And there's no limitation on 16 hours. You will see with respect in the Foster case, it was far longer than 16 hours or 2 days a month. I don't think that's enough. But in the Foster case, many, many hours imposed. That it's a real punishment, but it's restorative. It is there for the good of everyone. The biggest education here is to let people understand that the initial picture, initial understanding of a cold-blooded murderer was not a correct understanding. For whatever reason, that what we're really dealing with, on the facts found by the court, with a vulnerable person with anxiety that used excessive force when he thought, incorrectly so, that his life and that of the deceased were in danger, where he never, ever entertained the thought that the deceased was in the toilet, that she was exposed, that he thought she was in the bedroom. Those are the facts. Whatever way we see it, my lady, with respect and learned assessors, those are the facts. My lady, it is true that when you're in a hospital section, you become a patient, that there's only one doctor, your own doctor can come and visit you and they will take you to private hospitals. But that's not what it's all about with respect. It is the question, is that really a suitable punishment? Is that now that he must be treated like an awaiting trial prisoner? I never know, if I may say so, my lady. I know that they call, once you sentence an inmate, but it seems you're a prisoner when you're awaiting trial. I don't know what the correct term is. Where you have no privileges. You cannot go out and work. He must be in the hospital section with a small gym, whatever that is. That's what it is. It can never be. It can never, with respect, or hardly, be consistent with Ubuntu, consistent with restorative justice. It would rather show retribution. Deterrence, I don't know. I'm concerned because I've read may be nonsense about threats against him, how would he be seen to receive preference treatment? What would that do to him? How would that expose him? There are a number of factors, and I'm just really concerned about the suitability. My lady, page 77, we've dealt with that. Page 78, my lady, we refer to Ter Blanche, the guide to sentencing in South Africa. We found this book to be really, really instructive. And also there, my lady, he explained the difference between the community and the interest of community. And what is important is the statement made by the learned author, Professor Ter Blanche, saying any positive purpose, positive for the community, that is, which can be served by the sentence, should therefore be promoted in the interest of society. He carries on by saying, if future crime can be prevented by a sentence, whether by deterring the accused or other potential offenders, by reforming the offenders, or by protecting society from the offender by other means, such sentence will be in the interest of society. My lady, we deal with Ubuntu. We've extracted parts out of the book. We extracted the chapter by Justice Yvonne Magoro. We refer to page 80, the case of Maluleke. In Maluleke, the accused, the wife of the co-accused that died, either before the trial or during the trial, I'm not sure about that. They found someone stealing an house and they beat him up and he died. And the court carefully considered all the circumstances, and I understand circumstances different, and was convicted of murder. And the court did not impose a custodial sentence. But what is instructive is that is the instance where the court really seriously considered restorative justice and the principles of Ubuntu. And it's really instructive, my lady. We have made copies. I only saw this morning that the copies are small prints. I will ask Mr. Kruger to make proper copies of the pages in the bigger print. I had difficulty reading it. I did not realize, but we will put before you a new print of the copies in that's more legible, my lady. But it's there. I can just say at page 81, where the learned Judge Bertelsmann said, restorative justice seen in the context of an innovative approach to sentencing may become an important tool in reconciling the victim and the offender and the community and the offender. It may provide a whole range of supple alternatives to imprisonment. This would ease the burden on our overcrowded correctional institutions. That's the last part of the quote at page 81, my lady. My lady, page 82, we have dealt with the offer. That the money could be used for the good of the community, understanding the parents' approach to this, fully understanding. And we just point out there again, my lady, that the accused so desperately needed to apologize. We pointed out the letters written, given to, because it was very sensitive. We understood the emotions of the parents. We gave it to Mr. De Bruyn. He felt that it was not appropriate at the time to give it to them. We agreed with him. We respected his views. He wanted that opportunity to apologize. He did it in court. When Ms. Martin gave evidence, he again repeated that desire to personally. It's no use that I stand here. To personally do it. It tells us one thing. It's not an accused that wants to walk away from the pain caused. It's someone that desperately wants to make, not make right. You cannot make right. but to do something positive, to at least assist in the healing process. It's a difficult and sometimes impossible healing process. But at least it's a genuine and positive effort. And that is in that regard that the offer was made, to say, I want to do something good to the community. Please take that money, allocate it, give it to a deserving cause. At least that we feel it's positive, that something good can come out of this. And that is what we asked the court. In considering an appropriate sentence, it's the court's discretion, sitting objectively, but with the necessary compassion, that serious regard should be given to a community-based sentence, to restorative justice, and to strive to assist, not in a healing process, but at least to put some patches on the pain. And we asked the court to consider that in context. Thank you, my lady. My lady, one thing that I left out, but it is in the heads, page 76. Mr. Modise subscribed to the white paper, and it was instructive. I quoted it, but it's in paragraph 5.1.2, where he deals with the preference expressed not to incarcerate disabled people. But it's, of course, dependent on the facts and dependent on your discretion. But that, at least, was also a guideline. Thank you, Madam.
Thank you very much, Mr. King. Yes, Mr. Mel.
May it please the court, my lady, learned assessors. My lady, we're now dealing with sentence. When one deals with the merits of the case and the application of the law, it's all very technical. Lawyers would stand here and argue about how one would apply the principles of dolus eventualis, and that will go on for days. We're now dealing with sentence, my lady. Sentence is something totally different. When lawyers argue about the principles of the law, society would look at them and learn from them, or understand how they explain things. Now society is involved. Now society is involved. Our interests are at stake. The court have now made a finding. The court must now sentence somebody. The court must take us into account, society. What we want. My lady, society trusted the court over years to deal with criminals, to sentence people if they have to be harsh if the court has to. My lady, I will argue now, but it's really the following question. Society would sit back and say, what will happen if I walk in my house, I take a gun, I fire 4 shots through a door into a little cubicle, well knowing that there's a person inside, and kill that people? What will the court do with a person like that? That is what society is asking. But there's lots of other things. But in the main, well, lady, we've over months led evidence, cross-examined people. But it's perhaps now time, today, just to sit back, my lady, and to just think what happened that day. Just to think what happened to the deceased in this matter. We have to. This is the portion of the trial where we have to think about her. We thought about this accused, my lady, over months. We gave him the benefit of the doubt during every possible benefit of the doubt, which is correct, my lady, in the judgment. The fact that he's disabled, the fact that he was anxious, all those kind of things we took into account. I'll get to that. The accused want a double take at it. Please use all that in the judgment, but also duplicate that and use it in sentence. It was already used. The court made a finding, the lady, based on a reasonable man in the position of the accused with his disabilities. That's it. It was taken into account in reaching the decision the court made. My lady, I argue and it's on page 1. The court must take into account the crime scene. The deceased died in a small cubicle, behind a closed door, standing upright, facing the door. There were 4 shots fired through a locked toilet door with a powerful handgun. 3 of those hit the deceased. Well, we have to. The court has in the judgment, but it's now more important. It's not an accused that had a gun with normal ammunition that every other person would have. It was devastatingly damaging black Talon ammunition. My lady, we must, and Mr. Roux argued about how horrible it is to have shown the accused what the deceased looked like. My lady, apart from the court and the people sitting here, nobody else know. But the court must, with the utmost respect, my lady, today take into account what the deceased looked like, what the consequences of what this accused did to her caused, what it was, my lady. My lady, I know that Mr. Roux argued, and I know him well, that to lose a child is a devastating, the most devastating thing that can happen to any person. I agree with that. My lady, but I think we were lucky to have heard Kim Martin's voice. My lady, her voice goes beyond that of her family. It must be seen as a voice representing society. Although she spoke about the family, that's society. Every other mother that listened to her evidence felt her pain. I did, my lady. That pain we saw, that cry for please court, make this accused pay, my lady, was genuine. Real pain. My lady, it's ironic. We've had a trial where the screams of a woman, the noise of gunfire and the violent breaking down of her door with a cricket bat has predominated the proceedings. But our submission is, my lady, that the softly spoken words of Kim Martin, imploring the court for a sentence of imprisonment that will make the accused pay for what he has done, has trounced any other noise referred to and deserved the attention that she called for. My lady, when I deal with the offer, I deal with it on more than one occasion. But I deal with it in paragraph 11. Now, my lady, what is significant is the word offer. Not gift, not token, offer. An offer for settlement. My lady, that's in the press release. It was never behind the scenes, payment into an account. Don't ever tell people a box of cash delivered to a house. It wasn't. It was an offer for settlement. My lady, when I first heard that somebody would offer, and my lady, the offer wasn't in March last year. The offer was between judgment and sentence. It says so in that press release. When I heard, my lady, of the offer for the first time to a financially deprived family, I got sad, my lady. When I heard that a family was so financially deprived that they took 6,000 rand from the accused. Again, my lady, if I understood the 6,000 rand, it was always meant to be part of the claim that might follow. So it's not just a gift. But when I heard that a family had to take that, my lady, it saddened me that one would get to a situation where a family would have nothing and had to take that money. My lady, the offer is not something positive. It's in fact something terribly negative. It's, in my view, my lady, and I say it respectfully.
In your submission. In your submission.
In my submission.
Yes.
In my respectful submission. Made for purposes of sentence. The timing of that can just not be explained otherwise. Why 2 weeks before we started with sentence? Why not earlier? Why not later? Why not later? My lady, if I heard that after this case was finalized, Mr. Pistorius donated money to, or just gave them money, that would have been different, but no. And it's also, my lady, we keep it quiet. My lady, the offer is nothing but an attempt to influence sentence. We say in paragraph 11, my lady, the principle of a just sentence and the accused paying his debt to society cannot be equated with a cheap offer to pay for the life of the deceased by means of a car payment. My lady, when I know why it's said, and I know what the realities is, but I cannot but think, I sold a car for 375,000 rand, take this money because I did that to your daughter. But a man with enough means to sell a car to pay for the life of a daughter, my lady, that offer for the death of a loved daughter cannot be positive, my lady. And the accused mother referred to that as deceased mother referred to it as blood money. She didn't want it. My lady, we also deal with the principles of sentence, and as I've come to know Mr. Roo, both of our heads deal with the correct principles. So I'm not going to really deal with the principles, it's there. I just refer the court at page, paragraph 12 to a very nice summary by Judge Joffe, as he then was, in the Salebe matter. Isaacs, my lady, Isaacs that I referred to at page 13, paragraph 13, clearly indicates that there's something wrong with the Zin principles, and one must perhaps add to that the interest of the victim. My lady, when we say that, we respectfully argue that the interest of the victims in this matter should be an important factor taken into account. We understand, my lady, and I've seen that the parents of the deceased verbalize the fact that they stand neutral as far as sentence is concerned. But then we ask a question. How much grief, how much heartache, how much pain, how much trauma must one endure as a parent to get to that stage? Let things happen. Let things just happen. It's too painful. But, my lady, then we have Kim Martin's evidence. The evening before she gave evidence, the father of the deceased spoke to her and said, "Go do it. I wish I could, but I cannot. I will lose it." Those are the facts. We're neutral. We've had it. The pain is just too much. But I wish I could, but I will lose it. My lady, we argue that the courts owe it to society with respect to demonstrate that it will do what it can to prevent anyone having to go through the trauma that the Steenkamp family have had to endure. The heart-wrenching evidence of Kim Martin gave the court insight into the impact of this crime on a family, my lady, that still cannot cope with the loss of the deceased and will never be able to cope. My lady, for me, as representing the state, when I let her evidence, and for once I realized what the shock was. I'm driving in a car, I'm listening to a radio, I hear that the niece that I love dearly may have died. We turn around, we chase there, we walk into a house, it's chaos. People are crying. My mother and father are arguing. How will I see those people? My lady, that is what society wants the court to deal with. Not, I'm just sorry for what I've caused, for the consequence, and I get to remorse. I get to remorse. My lady, when the accused starts off with the heads, they deal with mercy. I understand mercy, my lady. I've argued sentence in many courts. I understand that if the court sentence, the court will, as far as possible, be merciful. But, my lady, we have to understand that when I ask for mercy, I ask for something undeserved. The mercy is undeserved. I can't claim it. I just ask it. So please be merciful. So, my lady, I'm saying, I know what I've done is terrible. I know what society wants. I know society wants me to go to prison, but be merciful and don't do it. That's how I understand mercy. But it's been accepted in our courts over years, my lady. My lady, at paragraph 14, before I'll get to that. Paragraph 14, my lady, we argue that the seriousness of a crime, the interest of society, and those are the victims, and taking into account the deterrent purpose of punishment, my lady, by far outweighs the personal circumstances of the accused. By far. My lady, we have a privileged person. We have a person that was in the top 100 most influential people in the world. We have a person, my lady, that comes to court and saying, please take into account that when this happened, I could have made millions. My manager, I called him. He said, you know, when this happened, I could have made millions, but now I can't because I killed the deceased. Now I can't. Feel sorry for me. Take that into account that I will not be able to make millions. My lady, that cannot be an argument. With the utmost respect. And so I know that I killed somebody out of a family that's financially destitute, but please take into account, if this didn't happen, I would have been a multimillionaire. My lady, he caused it himself. My lady, that is why the courts always say that sentence is predominantly within your power as the court of first instance. Because the court would sit there and can observe witnesses. And I think it's important because the court observed Kim Martin. The court observed the real pain. The court observed when she said, without detestation, she said, the sentence of correctional supervision is just not appropriate. My lady, if one carefully analyzes what is suggested and what we've heard is, we've heard, although he now killed the deceased, court, please sentence him to the following. He should go home. He should go stay in a luxurious house where he's staying at the moment, in Waterkloof. And he will not leave his house except if he wants to go train, if he wants to go work, if he wants to go to church, if he wants to go to doctor. That's what we do every day. Lady, I go home, I stay there, except if I want to go play golf or then I go back home. That's what the court must force him to do. Do all those things, but go back home. And be so kind as to 2 days in a month, just go do community service somewhere. That's all. For 3 years, you do that. Weighed up against what he did, my lady, it's shockingly disproportionate. I understand the principles of correctional supervision. I understand that in lots of cases it will be a proper sentence. I do. I understand the policies, and I'm in the NPA. We try and do that. We try and convince the court to rather, for not so serious cases, to rather impose that kind of sentences so that it can assist correctional services with the overcrowding. I do. But this is not one of them, my lady. This can never be one of them. My lady, and I'm not going to read it because I'm sure that every advocate that ever appeared before you referred to Karg. Now, my lady, it is a principle set down in 1961, and it's so valid today. In summary, if the court will not sentence a person to what society think is just, society may just take the law into their own hands. And that we must jealously guard against, my lady. We must jealously guard against the fact that society may lose their trust in court. My lady, I've listened to foster case, I've read the foster case. I've listened to what that mother said. And I do it with the utmost respect, my lady, to everybody concerned. I make the submission, I'm with her. We had a mother in that case that left the court thinking, my son was killed like an animal, and the accused is outside. I'm with her. I understand that. She's society. Did we not perhaps fail her in that matter, my lady, as the court? And we shouldn't fail the parents in this particular court. My lady, if we deal with the seriousness of the offence, and my lady, I'm really trying my utmost not to become emotional with this in my argument. But I want to use the word challenge, but I'll never use the word challenge. But, my lady, I'm sure that every right-thinking person would agree with me that there could be nothing worse, nothing, than to be at home and hear that your child died a violent death. My lady, what can be worse than that? I've thought about it. Nothing. This is what we're dealing with. Society is saying the parents were informed that the child died a violent death. What are the courts doing about that? The deceased herself did nothing to contribute to her death. She did not open the door and ran out. She did not open the door. She didn't touch the door. She didn't touch the handle. She did nothing, my lady. She stood upright behind the door. That's what she did. It's not an instance where there was a reasonable attack. There's not an instance where she did something in the spur of the moment that was perceived to be an attack. She did nothing. Those are the facts. She's totally innocent. She's dead now, but she's totally innocent. She died a horrific death. She's standing in front of the door. She was shot in the hip first. She had nowhere to go. She was in a small cubicle. 3 more bullets ripped through her body. If I think about that, it must just have been horrific. My lady, when I deal with the seriousness of offence and when I deal with the fact that there's nothing worse that can happen to a family but to be informed that their child died, then we must come closer to what we deal with here. We here have a family who made up in love what they lacked in financial means, uncontradicted. It's a very close family that spent every Christmas together. A daughter that just adored family and family life. This is what we're dealing with, my lady. Not the word culpable homicide, at the distance, let courts deal with culpable homicide without getting involved in the nitty-gritty of it. Unfortunately, my lady, with the utmost respect we have to. My lady, are we taking a break or shall I carry on?
What's your time?
It is now past 11 already, my lady.
What would you rather do? You want us to take a break?
If we can. If we take a break till 11:30 and then carry on from there.
We shall take our 15 minutes break.
Kan je ook rijden voor de blad?
ability, how foreseeable was this and not, to establish the degree of negligence. We refer the court to two passages from the record. Now, in the record 1873, I asked the question, did you ever think of firing into the shower is next to the toilet cubicle, a warning shot? My lady, spontaneous answer from this accused. My lady, if I had fired a shot into the shower, it would have ricocheted and possibly hit me. I followed it up. That's the next question. Firing into that door, in that small toilet, a ricochet of a bullet will be possible and it would hit somebody. Am I right? That's correct, my lady. My lady, if this accused realized that the ricochet bullet might hit him standing 5 meters or more from the shower wall, then how much more would a reasonable person appreciate the inevitability of firing 4 shots into the toilet cubicle? My lady, it's with the utmost respect, clearly not an instance where a momentary lapse in concentration had a tragic result. Not at all. To argue, my lady, that culpable homicide, where an accused shot and killed the deceased, is a serious offence, if one argues that, and then call for correctional supervision as an appropriate sentence, we say that you're only paying lip service to the seriousness of the offence. Our courts, my lady, have over years, and there are many, many cases, over the years accepted that the killing of a human being is the most serious offence it has to deal with. There cannot be any more serious than that, my lady. If somebody is dead, that must be the most serious thing that can happen to us human beings. That must be the most serious case that we as lawyers can deal with, that the court has to preside over, where somebody died. They're big cases, big fraud cases, big corruption cases, my lady, but the people walk out. They cause financial harm to people, which is serious. But when somebody dies, there's nothing more serious. Nothing. That's what we're dealing with. In the Nairo matter, my lady, that we've referred to earlier, the court indicated that as in murder, also in culpable homicide, the feature is that there was loss of human life. In Nyati, my lady, the court made it clear that where a negligent act causes death, the punishment should acknowledge the sanctity of human life. In Tatana, it's a matter that this court presided over. Taking the life of a fellow human being is always a serious offence, which leads to outrage and demands heavy punishment. Lady, in Ngumalo, which we refer to at paragraph 29, it said, the court must have regard to the degree of culpability or blameworthiness exhibited by the accused in committing the negligent act. Relevant to such culpability or blameworthiness would be the extent of the accused's deviation from the norms of reasonable conduct in the circumstances and the foreseeability of the consequences of the accused's negligence. Now, my lady, for sentence, that passage is the most important in terms of the seriousness of the offence. We say the accused's actions were so grossly unreasonable, he acted so hastily and with such excessive force that his actions bordered on dolus eventualis and that the sentence should bear that out. We say, my lady, that the cries of public interest are not unreasonable and must not be ignored when they induce an austere judicial approach to violent negligence, as we find ourselves facing in the matter. We're not dealing with a motor vehicle accident. We're not dealing with an assault. We're dealing with this accused, gun in hand, firing 4 shots into a cubicle. That's what we're dealing with. We're not dealing with a soccer referee being attacked by a mob, firing a shot blindly, hitting somebody like in Zach's case. We're not dealing with that. We're dealing with somebody firing a shot into a toilet door, well knowing there's somebody there. But, my lady, it goes further. We have taken into account that the court dealt with a number of aspects in the case which do not make sense. We accept, my lady, that the finding of the court is that these questions shall unfortunately remain a matter of conjecture. We, however, my lady, want to respectfully argue, for purpose of sentence, the court will just take the following into account. If the accused acted like a reasonable person, if he did, from that early stage in that evening, and ascertained from the deceased when he heard the window open, when he just did that, what a normal partner, a husband would do. Did you hear something? He didn't. If a normal, reasonable man would have asked the question, did you hear anything? If a reasonable person paused to establish whether the deceased had heard him when he spoke to her, before making his way to the bathroom, my lady, she would have been alive today. If he did any of those three things, which is, I agree with a number of aspects in the case that do not make sense. I agree with that. But, my lady, they don't make sense, and I understand that. But if he did one of them, if he wasn't negligent, over hastily, from that stage in the evening, she would have been alive. For sentence, the court should take that into account. It's not an instance where I stand before a door, the door open, and there's a startle and I shoot. It's not that. Not at all, my lady. It's not Madinge. Not at all. It's something totally different. His negligent actions, by not doing that, unreasonable actions, started before he reached the bathroom. His whole conduct was negligent and deviated from the acceptable, expected norm of the reasonable person. If one deals with the interests of society, my lady, there's always argument. I hear that every time I'm in court. Please don't break the accused. Please, with the sentence, be merciful. Don't break the accused. Right? And I always find it so incredible to think that his conduct to a loved one from a family, not only that, but broke that family. They did nothing. My lady, they're innocent. The accused want the court to believe that he's a victim. I find that very strange. I'm a victim. Feel sorry for me. The media victimized me. When I want the media to capture my brilliant athletic performance, I love them. When the media write about my trial, they're unfair. The state is unfair. They should not have prosecuted me in the way they did. But my lady, he's not a victim. He cannot be a victim. He caused it. We have victims in this case. My lady, at paragraph 34, we ask the question, how does a parent ever recover from the dreaded phone call breaking the news that your child has been shot and killed? How will Kim Martin ever forget and recover from the trauma of raising home and hoping that it was not Reva who had been shot? My lady, our courts have over years, and correctly so, we deal with it in paragraph 35, imposed sentences on those that have killed others in vehicle accidents to terms of imprisonment. It's correct. We should do that. In this instance, however, and far more devastatingly, the accused armed himself, walked to the bathroom, and fired 4 shots at the door, knowing that there was someone in the bathroom. His actions scream for harsher treatment than those who negligently cause death during vehicle accidents. My lady, we start, in fact, with paragraph 36, and we say, and admit, it's perhaps an oversimplification. But, my lady, society, look at the court and ask the question, what will happen if you do kill someone? What will happen if you fire 4 shots through a locked door, knowing there's someone behind the door in the process, you kill that person? We say an aggravating factor that overshadows all the cases that the defense referred to in their heads is to be found in the court's finding, my lady. And the finding is this. It starts at page 3316. On his own version, the accused armed himself with a loaded firearm and approached what he thought was danger, with the firearm ready to shoot. The accused clearly wanted to use the firearm, and the only way he could have used it was to shoot at the perceived danger. The intention to shoot, however, does not necessarily include the intention to kill. That is the crux of it, my lady, but that should be placed in context. Where does it fit in? It fits in with the unanswered strange things that I mentioned, without asking if she heard him, if she heard the window open, without establishing if she heard what he said. Then we get this. I arm myself, I approach the bathroom with the intention to shoot. Not to kill, my lady. I understand that what the court's finding there. With the intention to shoot. I'm going to shoot if I see something there. And then he shot. My lady, if one reads Naidu's case, Naidu clearly sets out two spectrums of negligence. We say this factor, the factor that he armed himself with the intention to shoot, gun at the ready, walk to the bathroom, remove this case from the spectrum of a momentary lapse in concentration in which an accused kills someone. We say it's perhaps on the other side of the spectrum of the degree of negligence, and it was described as, at the other end of the culpable homicide spectrum is a type of case where the accused had deliberately assaulted the deceased. We say deliberately fired shots. That we inserted that there. In the brackets is something that I inserted. Deliberately fired shots. But has not been convicted of murder because the state has failed to prove beyond reasonable doubt that the death was actually foreseen. So that's the other end. I do something deliberately. And then the state just couldn't prove that I foresaw that my actions may kill someone. But that removes it from, I had a gun in my hand, I was startled, I turned around, I shot. I dropped my gun, a bullet went off, it hit somebody. Those are things, my lady, where I would come to court and say, it's clear. It was a negligent, momentary lapse of concentration caused somebody's death. We don't have this here. My lady, as far as the personal circumstances are concerned, an important factor is that this accused, like in the cases we refer to, like in the cases where a court will impose a 276H sentence, we don't have an accused that came to court and was honest, forthright, told the court what happened. We had a poor witness with a plethora of versions. That's what we had. Up until today, apart from what Mr. Roux said, I don't know what the accused version is. Because he had so many. I accept the court's judgment. I do. But, my lady, whilst he gave evidence, it was unclear to understand what his version is. It was also unclear to understand what his version, the version was that he gave to Vergeer and Hartzenberg, because they couldn't tell us. They were careful enough not to pursue it, because I think anybody close to this accused would know that he will not admit that he, with intention, fired into that door. But then he was the only person who could tell the court, who could give the court detail about the things that the court had to say. I find it strange, but I cannot answer it. The only person that could answer that was him, and he didn't. Paragraph 40, my lady, remorse. I'm not convinced with that much respect my submission. My lady, when one deals with remorse, may I just use an example, my lady. You drive into a traffic light, over the red traffic light. You cause an accident. My car smashed, somebody else's car smashed. I get out and I say, I'm so sorry your car's damaged. I'm so sorry my car's damaged. What is remorse? I'm so sorry I entered the traffic light against a red robot. That's a remorse. Sorry about it. Not sorry, this now happened, so I have to be sorry because I caused it. I killed her. She is dead. We had a good relationship. I'm sorry she's dead. The fact that he's sorry she's dead is not remorse. The fact that he's sorry he shot and that he acted in the way he did, that's remorse. That's what the courts need. My lady, not that she's dead. That can never be remorse. My lady, even they arrived there, he prayed, he wanted the people to help her. Understand that. If you shot somebody, it's a traumatic experience, you want her alive. But the remorse, my lady, is when an accused verbalizes to this court, I'm sorry I did that. I'm so sorry I fired those shots through the door, well knowing there's somebody there. If we don't get that, it's lip service to remorse, my lady. I'm not saying he's not remorseful in an extent that she's dead. That it could be. And that I think he is. But not for what he's done. My lady, the accused, in spite of his physical handicap, coped brilliantly in life. It is with respect, and I say it with respect, my lady, I'm on dangerous ground, but disturbing that a man that wanted to compete with able-bodied athletes, never acted as a disabled person, would now shamelessly use this as an excuse and mitigating factor. My lady, Mr. Roux mentioned lots of things that's not on a record. I've read lots of things that's not on a record. I've read statements by handicapped people that was issued yesterday. I read lots of things. I will not argue it because I'm going to argue later that the court should not take note of that. My lady, the court took account of the accused's disabilities, anxieties, and fears in arriving at the conviction of culpable homicide. It is our respectful way disingenuous to argue that the same factors should play a significant role during the sentence phase. Well, it may be crude, but I'm going to do it because I'm going to illustrate it to the court. That one would perhaps think that we use our handicap as a handicap on call. When it suits us, we're handicapped. And I'm going to deal with it now. Because, my lady, we've been through cross-examination. We've been through Vergeer's report saying this man cannot go to prison because there are no railings in the showers. There are no railings in the baths. My lady, his house had no railings in the showers. The photographs handed in would indicate to this court that this accused shower in his main bedroom had no railings. The toilet we've seen hundreds of times, my lady. There's no railings there. But because we have to go to prison, we need railings. The bath had no railings. There is a railing. It's a railing to put towels over. I've checked them. They're in there, and I have them. But I'm sure if I'm wrong, in reply, Mr. Roux will say I'm wrong. But as I'm standing here, and what I did last night in checking all these photographs, I couldn't find any. If that is so, then it's disingenuous. Although evidence was led that he's anxious, there was even an attempt to indicate that he suffered from GAD. The strangest thing happened after judgment. He went out to a nightclub in the small hours of the morning. Not something, firstly, I'm arguing that. Not something, firstly, that the remorseful person would do. Secondly, not something that the anxious person would do by going out at that time of night, to a nightclub. Whatever happened there. As far as conditions in prison is concerned, my lady, we say, as bad a witness as Ms. Vergeer proved herself to be, so good a witness was Mr. Modise. My lady, yesterday after his evidence, I thought not only this court, but all other courts in the country can rest assured that our correctional services is in the proficient hands of a progressive and professional functioning State Department, with its sights set on keeping up the standards accepted by and on par with international counterparts. My lady, will it not be an unbelievable bad day if the international courts accept that our correctional services are up to standard to extradite their people to serve sentences? Because, my lady, I know Mr. Roux asked yesterday if Devan is not kept at Valkenburg. The agreement went further. If he's sentenced, he is going somewhere. On that condition, he was extradited to South Africa. My lady, I find it strange that there would even be argument by Ms. Vergeer about the prison conditions, but internationally it's accepted. But, my lady, we argue that the court will reject her evidence. Her evidence was sketchy, outdated, uninformed, generalized, negatively biased towards prisons in the country. I was, and if the court, excuse me using the word flabbergasted, when I realized that she based the report on a speech made by General Secretary of POPCRU in 2005, which dealt with the entry-level appointees in the department. She based her report on that, as far as statistics concerned. But, my lady, the one thing that in writing the heads, picked up when I thought back about what the evidence was, I think the court would remember that she stood there and said, but I have the 2012 report from the inspecting judge with me. I can quote from this. I never allowed her to, because never in a statement. And I was wondering, why would she have outdated statistics and not current statistics? And it became clear when Mr. Modise gave evidence. But the court can't, and I say it with the utmost respect, my submission is, the court can't now say, yeah, Modise fixed it up. The court must say, why did Vergeer not do it? So, my lady, we said evidence should be rejected. She conducted telephonic interviews with unidentified persons and relied on outdated personal visits to local prisons. My lady, it was in fact laughable when she testified that she visited Krugersdorp prison once 2 years ago. And that's it. That's what she based information on. But Mr. Modise shared his uncontested experiences of international visits to prisons and his 35 years service in the South African prisons. And whatever we argue about the prison's correctional services conditions, we say the court has to, with respect, at paragraph 48, has to find that correctional service structures will be competent and capable to cater for the accused with his peculiar disability and psychological needs. The accused, in his argument not to be imprisoned, attempted to isolate his needs from those of any other sentenced prisoner, including other paraplegics. Prison conditions, my lady, and this perhaps is important, prison conditions must be humane and dignified for all. My lady, to say, I won't get 3 meals in a plate with a fork and knife in prison, and therefore I cannot go, is not an argument. To say that I think it will be a terrible place to go is not an argument. If the head of the correctional services goes to all the trouble that Mr. Modise had to, flying back from Cape Town, to be in court and to tell the court, we can and will cater for him if the court sends him there. The court has to accept that, as the court is. The media, my lady. Lots of the heads of the deceased was spent on unfair media. He went so far as to say he might not have had a fair trial, I read. I think, if I correct this, paragraph 69 or something. The irony is, my lady, whatever Mr. Roux argued why he wants to present that evidence, the media can only affect you if you follow the media and allow the media to influence you. Nobody forced Mr. Pistorius to read the media. In an email that we handed in during a trial, he said, I've got a little black book. People that are good to me, I will allow them to deal with me again. The media people that are bad to me, I put their names in a little black book, I never talk to them. That's his attitude. But now he complains. He's been through the media issues. Now he complains, but he follows it. My lady, we find it very interesting that the accused would use numerous examples of negative media reporting to favor his argument. If, my lady, and I'm not doing it, but I just want the court to realize what we're dealing with. If the favor that he wants to rely on is accepted by the court, we may argue that the state would be entitled to find the overwhelming favor it would derive from an internationally released crime scene reenactment made by the accused and his team in preparation for trial. Not the video, because they're not presenting the evidence. They say to the court, all we want the court to take account of is the bad media said this and this and this and this. We can say, the bad media had a video which said this and this and this and this. But we don't. We can't do it. We have to stick to the record.
You can take it from me.
Yeah.
All those paragraphs will be disregarded
Indeed.
by this court.
Lady, I thought
I've
as
already
much.
said as much to Mr. Hu.
I thought as much, my lady, and I appreciate it. And that's the correct way of dealing with it. As far as the poor victim of an accused is concerned, because the proceedings were recorded, my lady, it is a fact, and we will defend this with everything we have, that court proceedings should be transparent and open to the public. Always. If somebody comes into court, must be able to report on it. Now, to say the mere fact that it was recorded is more detrimental than somebody sitting in court listening to it just doesn't make sense. This doesn't make sense. The principle is, it must be transparent. Or, my lady, do we want to say, it would have been so much easier to have all those lies and versions where nobody heard them in secret. Can't do that. To say to this court, please take into account this man was victimized because the whole world heard all these versions, is not a good argument. It's not, my lady. The courts should be transparent, and this court was. My lady, we argue that the only reasonable sentence would be a long-term incarceration. If the court would allow me, my lady, just to deal with one or two aspects in the heads of the defense. I've now dealt with my heads. The response the court gave me about the paragraphs would make this process much quicker. Yes, a good point. Lady, I'm not at all the case law that was used by Mr. Roux. There are portions in that I would want to quote to the court, but I'm not going to. The court will take account of everything that was recorded in those cases. In the Foster case, my lady, may I just refer the court to page 14? Of their heads, my lady.
Or of the heads. Do you say paragraph 1-4? Do you say paragraph 1-4?
No, I said paragraph 19.2, page 14 of the heads of the defense, my lady.
19.2. Yes, I've got that.
My lady, at paragraph 19.2, if one reads it, it is clear that even Mr. Foster did not foresee that he may shoot someone. We have a difficult here in that the accused knew there was someone. The accused version was that he was hoping to scare the intruder out and that his decision was one which was taken in haste and in fear against the background of his own constant anxiety about intruders. We have nothing like that. My lady, if that was perhaps so, if in this case there was an attempt to scare, that would have been totally different. Totally, my lady. If there was a shot fired into the wall, if there was shot fired into the shower, out the window, anything. But there wasn't. There was shot fired at the door, 4 of them. If there was one shot fired, perhaps, one shot, one could perhaps understand it. But that's not what we have. We have 4 shots fired by somebody that's competent with a firearm. So, my lady, that is to be distinguished from that case. But, my lady, I'm sure Mr. Roo will indicate that they did at page 17, paragraph 19.11, indicate that as far as this accused case is concerned, this accused created a more dangerous situation. They say, the facts in the Foster case bear similarities to the facts in eNCA. In this instance, the accused discharged shots into the toilet door, which created a more dangerous situation. So, my lady, that's a point I wanted to make. My lady, the arguments about the disability of the accused, I just repeat my argument. The court took that all into account in reaching the sentence. My lady, it makes it difficult for me, but this will be quick because all those issues that I really wanted to take the court up on, I don't have to. My lady, that's the one point I was reminded by page 38, my lady. But I find it very difficult to understand why the court will make a difference in this, why the court will deal with this accused differently. In other matters where the accused would approach the court to think of, consider a Section 276 sentence, either H or I, the person will say, I am employed. I can go out. I am employed. I will work. I will contribute to my family. I will contribute to society. We don't even have a suggestion in this case. Not at all. We have a fact. We have a denial almost, that he will not go back to athletics, or he may go back to athletics, and he may not go back to athletics. He may work for his uncle, he may not work for his uncle. My lady, it's a court, with the utmost respect, it's my submission, I do it respectfully, duty to deal with this aspect. What will he do if I consider this application? So if he doesn't work, what does that mean? He sits at home, works 2 days a month, and that's fine. That's how he pays for this, and that's what he wants to do. My lady, then the court will reject with contempt any suggestion that his prosthesis will be taken away from him in prison. There was no basis laid for it. And it was clear that it's illegal to do and that it hasn't happened before. So the court will reject that as an aspect. But, my lady, may also argue, and some arguments are more difficult than others, to make submissions to a court of how you see the court's duties, my lady. And I do it respectfully.
No, I'm open. Just remind me of the court's duties. That's why we're here today.
May I?
You have all the right.
The court's duty, my lady, is to look at the accused, look at the facts, and sentence him. It's a duty of correctional services to make sure that they can cater for him. The court will take that into account if it's impossible to do. But the court will not consider itself in too much detail about what happens once the court has sentenced him. It's a factor that the court may take into account, my lady, but my respectful view is the court look at the sentence, the court look at the facts, the court look at the person, and the court decides that this is a proper sentence. If we have a correctional service that cannot cater for him, then we come back. But, my lady, with the utmost respect, that is how I see the duty of this court. But it's not even a contentious issue because Mr. Modise made it clear that they will be able to account for the accused and to cater for him. My lady, as far as restorative justice is concerned, as far as Ubuntu is concerned, my lady, the most important portion of it all is at page 81. If one deals with restorative justice and Ubuntu...
Page 81 of the defense heads.
Indeed, my lady. Always don't go to 81.
Yes.
And it's that quote, my lady, and from the bottom is perhaps easier. 1, 2, 3, 4, 5. It may become, 5, my lady, from the bottom. It may become an important tool in reconciling the victim and the offender and the community and the offender. My lady, it's small things. It's really small cases that you can deal with. This is not a small case that we can deal with. My lady, it's not a bad principle, but my lady, it's not a principle that can even be considered in this case at all. My lady, that is my argument. My argument is that the matter is so serious, the interest from society demands an imprisoned term, and that this accused will be sentenced to imprisonment. My lady, I do agree with Mr. Roux. That doesn't happen often, but I do that the court will then declare the accused unfit to possess a firearm again. In terms of this conviction and also the negligent discharge.
Doesn't that happen automatically?
Well, my lady, the court has to do it, I think, in terms of Section 103. My lady, but if the court will allow me, I will address the court when we come back for sentence, specifically on the order that the court has to make.
Yes. Before you sit down, Mr. Nell, you mentioned a prison term. You didn't specify. I think you said something like long. What is long?
Yes. My lady, my respectful submission is that the minimum, and my lady, I've been in courts too long to go to 20 and hope the court makes it at 10. I'm not doing it. The minimum term that society will be happy with will be a 10 years imprisonment sentence. And, my lady, I could have started at 15 and hope that the court will suspend 5, my lady, but this is a serious matter. The negligence borders on intent. 10 years is the minimum, as a court pleases.
Thank you. Yes, Mr. Roux?
My lady, just 5 corrections. It was said that there's no rail in the shower, and he's disingenuous. You will see, my lady, at page 71 of the heads, paragraph 141.6, the accused gave evidence that there is a pedestal.
Hold on. Page 71.
Page 71.
Yes.
41 is a bench in the shower. My lady, the photo is image 8702, but it clearly shows that. I can show it to the court, but I believe the court will accept me. It's a photo of the shower. There is a built-in bench where you can sit on. The second part is, my lady...
But are you saying... No, surely the bench is different from a rail.
Yes, my lady, it substitutes the necessity.
That's
With
it.
the railing you would hang on, with the bench you can sit on and use both hands.
Okay.
It's actually what he needs. As regards the payments, my lady, all I can ask is when I read the press release on behalf of the family into the record that the court should have regard to that, and the comments that deals with the true position. It was not the accused suddenly, for purposes of mitigation and sentencing, offering monies left, right, and centre. There was an approach made and an immediate positive reaction. That's the real story. As regards a video on the construction of the events released, if I may tell the court, it was initially planned to make it easier for the court to have a reconstruction so that you can see the inside of the house. There were inaccuracies, and what happened then, contrary to a confidentiality clause and many letters that we have threatening them with interdicts, it was sold. Contrary to our wish, it was sold to the media. So it never released any video into the media suggested by Mr. Nell. It was in fact contrary to his wishes and in the face of threatening attorney letters. On the employment, Ms. Vergeer's report was quite clear what they do. That's one thing that they specifically deal with, for the person to get employment, to find employment for him, to encourage him to get employment, and if he does not, and he does not want to, they bring him back to court for resentencing, because then it's not an appropriate sentence. So it's not that you can sit at home and come 2 days and work. That's not what their evidence was. They do something positive about it. Page 81. The instructive, I agree fully with Mr. Nell, very, very instructive. What is at page 81, it's coming from the Maluleke matter by Judge Bertelsmann. He says, small cases, small things. It was a murder matter, my lady. It's not a small case and small things. It was a murder matter. So you can't change that. I just needed to correct that, my lady. I don't know if there's anything else that I can assist the court on sentence.
No. Just one. I think there's anything I might have overlooked. I think there's anything. Thank you very much, Mr. Roux.
Thank you, my lady.
Yes. Did you still need to say something?
But if the court will allow me just on the shower, because that's something new that wasn't in the argument. It's a fact, my lady, that there are no rails in the shower, no rails in the bath. If one can get by with a little bench, lady, then certainly in a prison cell, any prison cell, you can get a little bench to help you shower. That was my argument on that.
No, thank you.
So it remains a fact that there are no railings. Neither the bath nor the
Well,
shower.
I didn't hear Mr. Ruto say there were rails.
Yeah, no. As a good place.
Yes, thank you.
I just wanted to say on the bench, it was never mentioned, it's something new, and if that is it, we can take a bench to any prison. That's all I wanted to do.
Thank you. Thank you very much. I want to thank both counsel for your assistance and for your cooperation in this matter. I must say I'm very impressed at the way counsel conducted themselves and in the way that they assisted this court throughout. So thank you very much to both of you.
As a court pleases.
We will reconvene on Tuesday next week, which is, what is the date?
21st.
The 21st at 9:30 in the morning.
As a court pleases.
Court will adjourn.
Sign off, Raja Court,